this is ethical and other issues in lateral attorney movements. You can see the episode list on slide 7. You have a slide deck. Make sure you have it open. I'll be referring to it. Emphasis on the word referring to. I'll come back to that in a moment. The Financial Poise National Law Review webinar series. Um, this series is for you if you're thinking about making a lateral move, or if you need to deal with someone else's lateral move because either that person is on their way out of your firm or into your firm and you're involved in that movement. Unlike most Financial Poise National Law Review webinars, we're going to use one big deck for all 3 episodes. You'll see that this deck is 92 pages. It's got 3 breakpoints. Part 2 ostensibly starts at slide 32. Part 3 ostensibly starts at slide 58. Part 3, it only goes to slide 71. That's only a dozen slides. That's because the remainder of the substantive deck is an appendix of applicable model rules of professional conduct that we will be diving somewhat deeply into during each episode. So here's the deal. I've got specific questions I want to ask our panelists, and to the extent my questions raise information on slides that are ostensibly for other episodes, I'll certainly refer to them. Topics we only touch on in episode 1 will be discussed in more detail in episodes 2 and 3. So we're going to go back and forth throughout the 3 episodes of this series. And when I say refer to slides, I mean just that. When I ask a question and I know that the question relates to information on a particular slide, I will say the slide number out loud. And that way you can turn to it if you want to, take notes, etc. on your copy. But the panelists are not going to read the slides. That wouldn't be any fun. We're having a conversation. The slides will live in the background. Speaking of my handsome panelists, you may be wondering why they're letting me do all the talking. That won't continue, don't worry. Our panelists are Dan Binstock, Alex Edelman, Brock Nave, and Tina Solis. 3 are legal recruiters, 2 of whom are non-practicing attorneys. The 4th is an attorney who devotes a substantial part of her practice advising attorneys who are making a lateral move. I'm Jonathan Friedland, your moderator, and I've made more than one lateral move in my career. That's why I'm qualified to be here, to be the audience stand-in, if you will. Our names and firms are listed on slide 5. And if you want to see summary bios of each of us, you can do that starting on slide 86. No need to listen to me drone on for the 300 or more seconds it would take to read the bios or anything like that. The first rule of the first rule of Financial Poise webinars is that the audience isn't here to hear infomercials, and we know that. So with that said, let's go. Let's dive into it. Tina, and this is the way I'm going to do this. I'm going to identify the speaker I'm asking to kind of give the first response to. I'll give the other panelists an opportunity, but not obligation to weigh in. I will, if applicable, say a slide number out loud, and I will try to turn to it. And that's what I just did. Slide 11 and slide 12 are going to be the slides you kind of want to look at. Tina, what are the first steps an attorney should take once that person begins considering a lateral move?
Sure. Thanks, Jonathan. I think there are a few things, and again, I'm not going to read off the slides, but in no particular order, they are as follows. Number 1, a lateral partner should first think about engaging with a very good and experienced recruiter. I think that's critical in that recruiters can open up the doors to law firms that they may not otherwise have access to as someone doing it on their own. So I think that's the first thing. The second thing that someone who is considering a potential move should think about is, what documents do I need to gather and be familiar with? And a few off the top of my head. Number 1, the partnership agreement, if it's a partnership, if it's a corporation, the shareholders agreement, buy-sell agreement. If you have a particular employment contract in addition to a partnership agreement, you need to pull that out as well. If you've got a capital loan, if you're an equity partner and your capital's financed, you want to pull out those loan documents. And you need to start familiarizing yourself with those documents because what's in there is critical. And that leads to my third point, which is seriously consider retaining ethics counsel, someone who is familiar with these types of moves, knows the critical provisions in those applicable documents, and can work hand in glove with you and your recruiter in completing the process. So those are just a few of the top items, Jonathan.
Anyone else want to weigh in on what Tina just told us?
I would second what Tina said about getting ethics counsel involved. And in my mind, I think that um, when I see lateral moves, many folks who I engage with, attorneys who are considering lateral moves, are not familiar with the option to retain ethics counsel, and that and I'll just say right now, Tina is the best in the business at this, and then some. And getting ethics counsel involved early, very early, before you think you need them, is probably, in my mind, one of the most important things that a lateral candidate can do as they're starting to explore options and what their future looks like.
Brock, I say the term fiduciary duty is we're doing the ink blot test. What do you say? Slide 13, audience.
Going through the fiduciary duties, and certainly something very important to keep in mind kind of at the outset. I think that, and this is something that I definitely want to hear Tina's take on as well. Your fiduciary duty to your clients is paramount in the lateral process. And so that is very much the North Star. Your current firm, while you are still a partner, your duty to your current firm and to your existing partners is very important as well. And then, of course, your personal interests and your duty potentially to a future firm sort of comes third in there. So there are a lot of really interesting fact patterns, and I'm sure that Tina can speak to a number of those, where you see kind of crazy things that can come up, and you always have to handle these things kind of very much on a case by case basis. But generally, I would say the North Star is always clients first, and that can manifest itself in different ways.
Okay. Let's take a moment, and it's going to be, I think, so quick as to be hardly, it's not going to feel good. It's going to be too fast, but don't worry, we'll come back to them more. I mentioned the appendix. Tina, talk to us very broadly and quickly about the ethical rules. Audience, slides 73 through 83.
Sure. So before I do that, I want to pick up on a point that Brock made, which is you not only have your fiduciary duties that you need to think about, but you then have the ethical rules, which we're going to cover quickly. And then you also have to overlay both of those with the contractual obligations in your pertinent agreements. And that's one of the reasons I find this area so fascinating, is because it's an intermingling of all three of those that you have to address when you're tackling a lateral move. But some of the most important rules of professional conduct that we need to keep in mind are as follows. Rule 1.4 that talks about communications with a client. You have a duty to keep your clients apprised of any and all material facts that could impact their decision-making process. Certainly, you making a transition from one firm to another is a material fact. So Rule 1.4 comes into play all the time. Rule 1.6, confidentiality of information, also extremely important. You need to make sure that when you are working with your recruiter and through the lateral process, that you are maintaining the confidentiality of client information. And this really comes into play when you're filling out the lateral partner questionnaire and interviewing with the firm and for conflicts purposes, which we'll touch on in more detail here and in episodes 2 and 3. Rule 1.7, your conflicts of interest with current clients. Again, we'll do a deeper dive on this, but very important when you're running conflicts throughout this process. Rule 1.9, your duty to former clients. Again, here you have to understand this rule to avoid creating a problem for yourself during a transition. Rule 1.10, this is imputation of conflicts of interest. I cannot stress how important this rule is when you are exploring other job opportunities and completing the information in your lateral partner questionnaire or LPQ. Very important to keep this rule in mind and at the top of your head as you're completing the LPQ. Rule 1.16, this has to do with declining or terminating representation of a client. That is very, very important and something also to keep top of mind when you're thinking about a transition. Next, in terms of rules that we will discuss more in depth later on, Rule 1.18, duties to prospective clients. Again, very, very important to think about this rule when completing the LPQ portion regarding conflicts, because we not only have to think about the current clients that a lateral candidate has, but if there is something in the pipeline, we need to talk about disclosure in the LPQ and how to do that in a way that is consistent with the rules of professional conduct. Next, Rule 5.3. This has to do with responsibilities regarding non-lawyer assistance. This could be a topic unto itself for an entire webinar in terms of what you can say and cannot say to non-lawyer staff in connection with your move and when you can say it. So this is something we'll dive into later. And last, but certainly not least, one of my favorites, Rule 5.6, which is restrictions on the right to practice, that basically says a lawyer cannot undertake any sort of agreement that would impact his or her right to practice. And the basis for this rule is relates back to really the bedrock on which our entire profession is premised on, which is a client's right to choose his or her counsel. If lawyers had restrictive covenants that restricted their right to practice law, that in turn impedes a client's right to ultimately choose his or her counsel. And there are a myriad of ways that law firms and through their applicable agreements may try to place restrictions on attorneys. This comes up all the time in lateral moves, and thus Rule 5.6 pops up repeatedly in connection with making a move. So those are just a few that we're going to highlight and talk about in more depth, but that should give everyone a nice overview.
Overlay anyone? So I'm going to take us in a different direction, just for a little bit, and tell us, Brock, I'll ask you to start us 14. When should an attorney engage a recruiter or a group of attorneys, if it's a group that's thinking about moving, engage a recruiter or consultant in the process?
So, I think, and the caveat here is that I think if you end up working with a good recruiter, they are an incredible strategic partner and will open doors and really, help you sort of from soup to nuts. And so I think if you have a great recruiter, it can be very helpful to have that person engage from the get-go, or really even better, I think, to have a great recruiter who you trust, who you're sort of catching up with on a periodic basis, to check in on the market, understand whether you're meeting your current goals where you are, if other platforms could help you do that in a way that your current platform's not able to. So really, if you have a great recruiter, you want that recruiter involved as early as possible. It can be tough sometimes. I've noticed that not all lawyers understand how the relationship works between attorney candidates and recruiters and law firms. And so sometimes you'll see a candidate try to get a recruiter involved after they're already down the line in a process with a firm. And that is typically a bad look for everybody and does not help the process. So as early as possible, with the caveat that you want to have a great recruiter involved, and a bad one can really muck up the process at any stage.
And
If
I want to add something here, because I think our audience are attorneys for the most part. You're an attorney, whether you're staffing a deal or staffing a litigation matter, that's the first thing you do after you have the project is you get your team around you. It's no different in a lateral move. You want to get your team around you, and your team should be a recruiter. They've been through this process hundreds, if not thousands of times. They know what the law firms are looking for in connection with the LPQ, and you get your ethics counsel involved. And so I think one of the takeaways from, these initial few slides, get your team together.
Yeah.
And do it at the outset.
I'd like to add one thing, Jonathan, if I could, which is to follow Brock for a moment. The longer that I've had a relationship with a potential lateral, the easier it is for me to represent that person, especially when I'm speaking with my firm clients about that candidate. I have the benefit of saying, hey, I've known this person for 5-10 years. I've watched them build their practice. I've heard from other people that they have a good reputation in the bar. All of these things matter, and if the client presumably trusts me, then they will also trust my relationship and understanding of the lateral candidate.
And thanks, guys. And Tina, I echo everything you all are saying. And one thing I want to add just on this point, and then we'll move on, is that one reason it's so hard for partners to understand this issue at the outset is because it seems that all I need to do is pick up the phone and call someone. I know someone. How hard can it be? Why do I need someone else to introduce me to someone else that I don't know? But it's not until you're, in the second or third quarter that you realize, oh my gosh, all of these things are getting much more complicated. It's kind of like filling out a life insurance application. It's not hard to fill it out until you realize, well, most lawyers probably don't have to fill them out because they're through their firms. But, something that's difficult, you don't realize until later on in the process all the things that you may have done wrong in the initial application. So while it seems easy, it's very deceptive in the sense you won't know until later how much you may actually need the help. And that's one of the big challenges, I think, with recruiting overall, is you don't know how much you need it until often it's too late. And once you apply to a firm directly, after that point, you cannot engage a recruiter absent some very unique circumstances where the recruiter may have an outstanding relationship with the firm. You're on your own with that particular firm. So it's really important to understand the first in time rule and how that can affect you.
Hold on, I have a question. So let's say I'm talking to a firm and I didn't come, I don't have a recruiter, and then I realize that shit, I'm in over my head. I understand recruiters work on a commission basis, but there must be some good recruiters out there who are willing to help me if I say, look, I messed up. I didn't hire a recruiter. Can I pay you on an hourly basis? Do everything but the intermediation. You're not introducing me, but you're giving me all that other good advice.
So
That's not
it,
available on the market.
it's a great question. A really good question because a number of people have come to me and said, "Can I now engage you?" For me to charge someone on an hourly basis probably isn't right to them or right to me based on sort of the nature of how our business works. What I would do, and I'm sure probably Brock and Alex and most experienced recruiters would say, let me try to help you as best I can with what I know, but I'm still on the sideline. My hands are a little tied, and I'm only seeing part of the deal. And so if I'm coming in at the sixth inning, I've missed everything that's gone up to innings 1 through 5. So for me to give good advice at that point, I'm really limited in what the early conversations were, how things were presented. So I'm not able to do my job effectively unless I'm starting in the beginning and I see how everything's formed and developed. I can still give advice and try to help from the
Okay.
sidelines as best I can, but it's not that effective. It-
Anyone else willing to take my money if I'm willing to pay on the hour on the panel?
No.
Okay,
Uh,
so,
yeah, we don't get
yeah,
too many problems.
okay.
well, and I mean, we'll probably get into this later, but I want to be successful and give good advice. And it's very challenging to do that, frankly, when I'm not communicating with half of the parties involved in the deal. And one of the benefits to being a really good legal recruiter is that we have relationships with law firms, and not just the recruiting staff at the law firms, law firm partners, people like Tina that we can call up and talk to about the process and talk to about the candidate. I can't do that if the firm won't allow me to represent the candidate.
What do you mean that the firm won't allow you to? If I say, look, I want to use you as my outside advisor, I'm bringing you in, what's the problem?
We have contracts with each law firm that dictate when a firm will allow us to represent a candidate.
Ah,
Ultimately, and this is actually probably a really important thing to clarify for those who don't know it, legal recruiters are paid by the law firm when the law firm hires the candidate. And therefore, technically, our client is the law firm. And so we are bound by their set of rules and restrictions.
oh, that's interesting. So if I get contacted by a recruiter, um, that recruiter is working is contracted with a law firm or many law firms. It will that recruiter will help me figure out what law firm or law firms, or firms I want to look at. Or let's say the recruiter is calling me because I get these all the time. They're calling with a specific mandate. They're looking they're looking to fill a position for firm X. So if that happens, is this like buying a house? Like, there's a seller side broker and a buy side broker. Do I need to get my own recruiter to to deal with the recruiter that works for the law firm? Anyone?
Uh, yeah, I can jump in on this. It's a great question, and recruiters wear multiple hats at different times. So a metaphor that I'll use here is let's think about just who's the recruiter as a quarterback. If someone comes to me and says, Dan, I want to go to market. I think that there's something better out there. I've got a challenge, conflicts, whatever it is. Help me find a better place for me. I'm now the quarterback for the candidate. even though I may place them at a firm and a firm pays me and my fiduciary responsibility is technically to the firm, I am going to be a very strong advisor for that candidate. And if you've got enough experience, you're able to work in a way that is mutually beneficial to both sides. You're not withholding information that the firm would otherwise want to know ethically. And this opens up a whole other can in terms of what are you required to disclose. So if this person tells me something negative, there's a whole host of issues in terms of how to handle that. If I'm calling someone in the market, if it's an in-house search, that is a situation where they're really truly working for the employer and they're the quarterback for the employer. If I'm working on a lateral partner search where it's an exclusive or retained search, I'm working for the firm, but oftentimes, in order for me to work for the firm, I need to be also working for the candidate as well, because a candidate is not going to be comfortable with the process if they don't feel that I'm also looking out for their interests, despite the fact that I've reached out to them regarding the firm and on the specific request of the firm. So it's a very weird kind of gray area of fiduciary duty. However, you're spending sometimes 70% of your time and advice and counsel to someone with whom you don't have a technical fiduciary responsibility, but you're invested in making sure that this is a good fit for them and the employer. So, as a good family therapist would say, there are a lot of crossed boundaries going on here, but that's often the way it works.
Okay. Any last overlay on this line of questioning?
Jonathan, one other thing with the question you asked that I think is interesting. So, in the context where I think every attorney listening today probably gets 10 or more emails and phone calls a week or maybe even a day from recruiters who are reaching out saying, I'm working with this firm or with this company. And I think that in this day and age, you have to be really, really careful in who you choose to engage with. And more, I mean, I've seen a number of examples over the past several months, increasingly so, where somebody who it is unclear to me if they are a real person, it reaches out ostensibly at the direction of a chairperson or a group head, and says, hey, I'm working on this retained search. And it turns out that you look under the hood a little bit and it's totally untrue. And so I think that there is, in this business, the commissions are big and there are very low barriers to entry in legal recruitment. And so there really is a high degree of care needed in determining which recruiters to engage with and properly diligencing if those people are who they say they are and if they have the contacts and relationships that they say they have.
I actually always assume, like police have the internal affairs where they investigate the police. I always assume that if I get an email like that, it's actually coming from inside my firm. Just to suss us out if we're
I
thinking.
haven't heard that one yet, but I do know with the tech trainings that they'll get you in that way sometimes. So
Well,
maybe
I'm highly
recruiter
confident.
emails are next.
So I was just handed a note. Seems like I forgot to mention just a few important PSAs, important depending on who you are, I guess. Slide 3 reminds everybody that the National Law Review's Career Center is an enormous resource and you should know about it, audience. You can look for, not that you shouldn't look for jobs through recruiters, but firms and recruiters place ads. It's a source of information. It's like a help wanted, but it's also a lot of other information. Tina writes a column for the National Law Review. Slide 4 is a disclaimer that all Financial Poise NLR webinars have that basically says, you're not our client's audience, we're not your advisors. This information's for, educational purposes only. And if you want to be able to sue someone for malpractice, then go hire somebody. As Ringo would say, I say that with peace and love. You can read
Peace and
more
love.
about peace and love. You can read more about the National Law Review on slide 92 and about Financial Poise on slide 93. Okay, back to our program. That wasn't too painful, was it?
I love that. I love that Ringo Starr reference because I love that drop that I hear all the time.
Are you a Howard Stern fan?
Yes, peace and love, peace and
Yeah, that's
love.
where I get.
Yeah,
I'm a Beatles fan, but I wouldn't have known that but for Howard Stern.
right.
But we digress. We can have a sidebar later. Okay, so the next question I am about to direct Alex. So Alex, get ready. Audience, we're on slide 14. And speak ever so briefly about the full suite of services a recruiter typically offers. I know we talked about that sort of implicitly, but the point is, did we leave anything out?
I think that Dan did a good job sort of kicking this question off with the analogy of a quarterback. But what I always tell the laterals that I represent is that I wear different hats at different phases of the recruitment process. And I generally tell people, first and foremost, look at me as a trusted advisor. I am here primarily to give you good advice and to help you navigate this process with the idea that my business is built entirely on my reputation and my brand. And so just like an attorney, I try to give the best advice I can. And the hope is that a candidate will think that this is good advice and it's helpful, and therefore that'll improve my business in the long run. But the four sort of main parts of what I do, the first, or what we do, the first is we're brokers, right? We can take a lateral candidate or a group of lateral candidates to market and show them to our clients, show them to law firms, but also educate them about the market. Tell them trends, who's looking for what we're hearing, because at the end of the day, we're sort of in the business of collecting information all day long through the conversations we have. Then I sort of transition into being a therapist. We talk about feelings, we talk about vibes, we talk about emotions. And this is the point in the conversation where I feel like we develop a strong connection with the candidate or the group of candidates. And I mean, many of them become my friend. And I feel like I'm giving advice to a friend about what they should do with their career. The benefit is that recruiters, good ones, we see a lot of these conversations. We see a lot of different scenarios. And so we can talk about our experience. Then as the process shifts into the offer phase, really we become like an agent, like a sports agent, negotiating deals, making sure that the contracts have everything that the candidate or the group of candidates wants. And this is the part of the phase or the part of the process where I really rely on Tina and outside counsel like Tina to make sure that the offers that are put in front of our candidates and ultimately the agreements they sign look good. Not only are they standard in terms of the market, but also what the firm is saying is what our candidate is agreeing to in writing. And then the last sort of hat that I wear is advisor. Once a candidate has hopefully received multiple offers, I help them make a decision.
All right.
I love the way you explain that, Alex. It's such a good, succinct way, and I love the way you explained that. And also, when you were talking about, advisor, Brock, you've posted some stuff online about decision making, and sort of. I also love what you write and post about sort of the psychology of decision making, which is often such an important part of what we do, because a lot of people make decisions by their gut. They say, my gut's telling me this, my gut's leaning here, my gut's leaning there. But what we don't know is whether someone's gut is actually truly their wisest self, or whether their gut is their fear masquerading as their gut. So a very skilled recruiter can help people peel away as to what their gut really is, and if their gut is their wisest gut, or if it's perhaps a fear-based gut. And those are the types of things that I imagine me, Alex, Tina, and Brock, we all probably love this people element of helping people through these difficult decisions and going beyond what the obvious might be.
So, as a lawyer who has made a lateral move, um, when I considered when I was trying to figure out who will I hire as a recruiter, um, you know, this was a long time ago. I felt kind of clueless. I put up slide 15, and the question, I guess the way I'll articulate the question, and Brock, I'll address it to you in the first instance, open-ended. What about picking a recruiter and contracting with a recruiter? Is there a standard contract that's sort of industry standard? And one thing I'd like you or someone to address in particular is this. Um, so one of you said earlier that, you've got recruiters have contracts with various law firms. Like, I can bring you these candidates. If I pick the wrong recruiter, is it possible that I'm leaving, if that recruiter doesn't have a relationship with firm A, B, C, or D, does that mean I'm simply not going to be able to get in front of A, B, C, and D if I'm going to stay loyal to that recruiter? Start with that, but then, because I'm curious, it's all about me. Um, start with that, but then be more general and help me understand if
Sure.
I ever were on the lookout for a recruiter again, how I would do
Yeah.
that.
So there is a lot to unpack in this one. So I think the biggest risk you have in engaging with a recruiter and getting the wrong recruiter is not necessarily that they don't have the proper relationships and will fail to communicate with the right firms. It is that they will communicate with many firms in the marketplace in a way that is nonsensical, and they will actually destroy your credibility with law firms. So I'm sure Alex and Dan, we could all tell horror stories about this time and time again. It's all the way from, I think one of the, as we think about due diligence before engagement, you want a recruiter who is an adult in the room and has the ability to have communications at the executive committee, practice group head level, and really understands the particulars of your practice. And so I would say when you're doing due diligence, it requires a lot of discussion up front to understand who the recruiter's relationships are with, to the extent they're able to disclose some representative transactions that they've worked on, what their background is. I always, think that folks who have practiced law or worked at large firms have a leg up in that regard. And you really, especially as a partner, you want to make sure that you are working with someone who is on your level in terms of professionalism and contacts. And so really, I think that often attorneys do not do enough diligence on recruiters up front. I just heard a story a couple of weeks ago. A colleague of mine had been speaking with a very high profile M&A lawyer. And that person had a random recruiter call and reach out a couple of days before, They said they were working with the chairperson at a top 10 law firm. They actually got the chairperson's name wrong. And this is an 8-figure partner, and said, didn't catch that they had the chairperson's name wrong, but said, oh, sure, go ahead and check out with this firm. And they went through the wrong avenues to do it. They didn't properly present this person. They didn't highlight synergies. So that's an example of how this can go wrong. And at the end of the day, it's just diligence, diligence, diligence upfront. And be very clear with recruiters that they do not have your authorization to communicate with anyone on your behalf, unless you've given that to them explicitly.
Who wants to weigh in before I move us on along?
You should work with someone who understands what you do. I focus my recruiting on several key practice areas, and I don't really stray from that. And when a candidate comes to me, says, hey, I'm an IP lawyer, I'll say, look, let me refer you to another recruiter who knows the IP bar, because I certainly don't. If someone publicizes themselves as sort of a jack of all trades, or they, they do a mix of things, I would ask them a lot of questions. The other thing that I always tell candidates is, when you're shopping for a recruiter, interview multiple recruiters. You should talk to multiple people to see who you work best with. And you should also ask around. Ask other people in the bar that you know and respect. Hey, who did you work with? Or ask your firm what recruiters your recruiting department uses. Because chances are, if they have good relationships, they'll be known to those around you.
Wait, did you just say I
But-
should ask my own firm?
Well-
Someone at my own firm?
I wouldn't ask someone and say, look, I'm thinking about a move, but I would certainly, if you're involved in your firm's recruiting process, I don't think it's a problem for law firm partners to
No, that's fair.
know which firm, which recruiters their firm uses.
And I still don't feel, no, I'm not talking to you in particular, Alex. I still don't feel that I've got a clear answer. If I think I want to go to firm X, Y, or Z, should one of the first questions I ask a potential recruiter that I might engage, do you have a relationship with firms X, Y, and Z? And if they don't, does that mean I can't work? I should not work with them?
There, I can take this one. You guys can chime in on what I may miss here. But so if you came to me and said, I'm interested in 3 firms, one of those firms, a firm I've done a lot of work with, 2 is I've done some work with them, 3 is I haven't done work with them at all. Let's focus on situation 3, because that's what you seem to be sort of really getting at here. If I've never done work with the firm,
It's for a friend.
yeah,
No,
right.
I'm not
If I've never done work for 3, it's really a warning sign, it's not a deal breaker. But if I've never done work for 3, I don't know how the decisions are made. I don't know what the partnership agreement looks like. I don't know what the compensation structure looks like. I don't know what some of these core things look like. So my ability to advise on what they should be asking is I'm starting off at ground, at the beginning. So they're going to probably have more, but this comes down to sort of the insight part of the process in terms of the information that Alex talked about at the outset. But the firm may say, we'd love to work with you, Dan. We just haven't had the chance yet. We don't have an agreement in place, but here's our agreement. We'd love to work with you. However, so it's not that you can't work with them, but here's a big important distinction. Some recruiters have firms that they take from and that they place into. So firm 3, I personally don't run my practice like that, but if I'm a recruiter that has firms that they take from and place into, if I've taken a bunch of people out of firm 3, firm 3's management knows that I'm not a friend of the firm, that could really negatively impact the candidate if the firm does not want to do business with me, and there's some hard feelings about people that I've taken out with in the past. So I think for the candidate, the right question is, here's the firm that I'm interested in. How do you work with that firm? If so, how regularly have you placed people in my practice area? How familiar with them are you? Are you conflicted out of working with them for any reason because they're a firm that you take from? I think if you ask all of those questions together, you're going to get a pretty good idea of how much this person's going to be able to help you. Now, there may be someone who's great at step one, they know a lot about the firm, but when it comes to being a therapist or an agent, they drop the ball because they're not very good or skilled. So they may be very good at the first part of it, but when it comes to 2 and 3, they're not very good. So there's so much more than just how well they know the firm. The best recruiters have sort of all of those things wrapped together, which is why it's so hard to find the right recruiter for a particular person's practice because there's so many
Okay.
different variables.
I want to jump in here. I'm a little outside my wheelhouse, but I say this to clients all the time. Do you have a recruiter? You should have a recruiter throughout your career, just like you might have a career counselor or a life coach. Develop that relationship because it's like anything else. If you develop a good relationship and you have a good rapport with your recruiter, and I think, Alex said sometimes they become my friends, your friends are going to work a lot harder for you. They just will. It's human nature. So, again, when you're picking up as an attorney, for all the audience out here, when you're picking up team members throughout your career, start young, do your due diligence, make, interview recruiters, find somebody that you work with, that you like, that you enjoy, that have good bedside manners. Because let me tell you, going and looking for another job, any candidate's going to tell you it's one of the most stressful things. It's a second full-time job. So that therapist aspect, I will tell you, it's critical. But find somebody that you like and then use them and continue to use them throughout your career. I think it's some of the best advice that we can probably give here because that person is going to work with you and work super hard for you throughout your career. And the better they know you, the harder they're going to work for you.
So I'm not young. I'm closer to the end of my career than the beginning of my career, but you convinced me. Tina, pick one of these three guys. Which one do you like the best? Which one should I work with? No, I'm kidding. I'm kidding.
You can't ask me to do that because some of my
Right.
favorite people on the planet are on the screen right now. So
my real question is, Tina, close your ears. My real question is about Tina, guys. And it's not about Tina. It's about the generic lawyer who does this kind of work. Not that anyone is generic, but I'm turning slide 16, and call me skeptical. Call me a cheapskate. But if I'm going to use a recruiter, I'm not sold yet that I also need an attorney. After all, I think 2 out of 3 of you, as I said earlier, you are attorneys. So, do a little bit more.
Convincing
What do
you,
you want to
convincing
see?
you.
What do you want to? You have 30 seconds, 60 seconds to convince me, Dan. I want to hear from uh Dan, and then I want to hear from each of you. Dan, go.
Yeah, so you wouldn't represent, if a client came to you and wanting to represent themselves in a deal, even if they're an attorney, you want to deal with someone that's seen 50, 100, 200, 300 of these situations.
Okay, I know, I get that argument.
Okay,
I get that. Next argument.
how much money, are you potentially making at this new firm? X, let's say 2.3 million. All right. What would be the downside of speaking to a lawyer about this, just to have a second pair of
Got it.
eyes and ears?
Fine. Okay, Alex, any additional argument you want to overlay?
Yeah, every lateral move is like an M&A transaction. If you are a lateral partner, you have a business, you own a business. whether or not you think about it that way, that's a reality. And you wouldn't consider selling your business or adding a partner to your business or making a business decision without consulting a business attorney. I look at attorneys like Tina as sort of the best suited advisor, in addition to a recruiter, to take you through that process and at every inflection point be able to issue spot. I'll out myself as the only non-lawyer on the panel. I am not a lawyer. So for me, Tina and attorneys like Tina are a valuable resource in that they know the law, especially in jurisdictions where I might not do a lot of work. I'm based in Washington, D.C. This year, I've placed a number of partners in Texas. Tina and I have had some long discussions about the particulars of partnership agreements in the state of Texas. So having someone that knows the right questions to ask is invaluable.
And by the way, I'd imagine that maybe someone on the surface might be like, oh, all else being equal, I'd like a recruiter who has a law degree, but I wouldn't buy that because
Wh-
unless, correct me if I'm right, guys, but I'm assuming that if I try to sue you for legal malpractice, even though you happen to have law degrees, your contracts protect you against that. You're not practicing law when you're dealing with me as a potential lateral.
Yeah.
Yeah,
And
we're not wearing our lawyer hat at all. Like we are not, the fact that we were lawyers
Right.
just, it means virtual, we can issue spot perhaps, and we're able to maybe talk the talk a little bit better. But the other thing that I think is an important point is that a lot of candidates assume getting counsel means it's something adversarial, that the new firm's going to know that they have counsel, that it means that there's going to be some sort of fight or that they need representation in an adversarial context. A lot of times someone can work with Tina and the new firm has no idea. This partner is just extremely sophisticated in the questions that they're asking. And they may say, all right, they're smart enough to know to have a lawyer because they're asking really good questions. But it does not mean in any way that the new firm needs to know that you have representation if and until you decide that there may be a situation where it's better for Tina to step in. So don't confuse having a lawyer with meaning the new firm's going to know you have a lawyer.
And what you just said is a really good segue for me to, well, segue, I guess. Um, because our use, if I'm the audience as proxy, I'm the potential lateral, and I'm looking to hire counsel. Advice in negotiating my new deal is only half of, not by number, but it's one part of what I'd be hiring an attorney for. The other part, which we touched on before and we'll really get into, in well, this episode's almost over, but in subsequent episodes is the exit, right? There's the exit and there's the entry. And for the last number of minutes, we've been really focused on the entry into the new firm, but the exit from the old firm is full of potholes and landmines we don't want to step in or on. Speaking of which, um, Dan, why don't I ask you, everyone, like all the questions, everyone gets a chance if they want it, but I'll throw this one to you. What are some of, can you name one or two big mistakes made by lawyers when initiating a lateral move specific and particularly apropos to what I was just saying, I'm looking at like legal ethical mistakes vis-a-vis the law firm that is being left.
Yeah, there's so many buckets this falls into, but the first one that is the oh my God, you didn't do that, is when they'll say, oh, and by the way, not only do I want to leave, but I was talking to two of my associates and they would want to leave as well. That is just like 101. Do not talk to anyone other than an equity partner. And if you're thinking about a non-equity partner, that's where, depending, I would kick this over to Tina, but do not talk to anyone that's considered an employee, because that is one of the most obvious slip ups that can happen at the outset that can come back to bite people. Um, the
Oh, so
second,
that's interesting. When
yeah,
I left my limb, I left with another equity partner. And if that person happened to not be an equity partner, if they were a non-equity partner, and if I happened to have initiated the discussion, that would have been a landmine.
well, it depends when the discussion is initiated,
Hmm.
whether your current soon to be former firm knows, but I would kick this to Tina in terms of the specifics of this, but the timing is also very important.
So Jonathan, you would have been okay because you're in Illinois and you practice in Illinois. And Illinois has a case that specifically allows partners to speak to other partners, be they equity or non-equity. And so there are a lot of states that have that similar rule. However, there can be caveats. And remember, at the beginning of this episode, we're now coming full circle, Jonathan, where we talked about it's not only the contractual provisions, but it's the rules of professional conduct, and those are intertwined. In some jurisdictions, it's allowed to speak to non-equity partners. In others, you have to be more careful. But Dan's right. Associates off limits. The council, that's a sort of a new title that a lot of firms have started using in the last few years that sort of bridges the gap between senior associate and income partner. Council are off limits in most jurisdictions. So I think Dan's right. That's one of the biggest mistakes that can be made in a move is talking to individuals on your team that you should not be talking to until the appropriate time.
You
And
preface that with sort of from an ethics standpoint. Um, if we're talking about from the other standpoint, there are so many things, but I would also say understanding the timing of the year and when you leave and the impact on how much you're going to be leaving on the table, which I know we're going to be talking about in subsequent programs. But those two, and I'd be curious as to, Brock, Alex, other things that you all see, but those two jump out at me as the two biggies.
Yeah. The other one to me is notice and release. And I feel like a lot of folks, certainly, especially when you're thinking about timing for distributions and timing for client purposes, it is always, paramount to be able to get to your destination firm. Once you've made that decision to join, it's paramount to be able to get there ASAP. And Tina, you've seen more notice provisions than any of us. I mean, 30 to 90 days, in my opinion, is kind of the typical range that you see in the marketplace. But it feels like more and more, especially with the ABA guidance, that holding folks is perhaps deemed unreasonable. And Tina, I know on a number of things we've worked on, you've been very successful in getting people out in a matter of days when their firm was aiming to hold them for a month or longer. So, in my mind, I mean, you know, that on its own, there are a million reasons how Tina, you've been our ace in the hole on deals, but I think the notice and minimizing the timing between when you give that notice and when you're released and able to be admitted to a new partnership is critically important. And ethics counsel is so helpful in politely agitating to get out in the near term.
Okay. We're just about out of time. I don't want to start a new question, but I do want to invite you guys. Tell me something that you want to tell me before we leave that I should maybe think about until episode number 2. Anyone?
Um,
Go,
thank you
Dan.
thank you for opening this topic and letting us really dig deep into it, although it something that a lot of people don't talk about, and there's a uh, massive hole in terms of education about recruiters. So thanks for letting us go into this topic for so long because it's one of the main things that partners regret not knowing about sooner.
Who else? You can't give me another compliment or another thank you.
Uh,
What didn't I ask?
I'll give a teaser to the
Good,
audience and the
good.
reason why they should tune into episodes 2 and 3. I'm going to throw a bunch of issues out there, and if you don't know what I'm talking about and you're thinking about a move, these are all the reasons that you should join us for episodes 2 and 3. Do you know what it means to be over distributed? Do you know what clawback provisions are? Do you know what financial disincentive provisions are in partnership agreements and whether or not they're enforceable in the jurisdiction or jurisdictions that you practice in? Do you know what your applicable agreement says about the return of capital if you were to withdraw? If you don't know the answers to all of those questions, I would invite you to join into episodes 2 and 3. So there you go, Jonathan.
Thanks. Fellas, you got anything you want to follow that?
I agree with both Tina and Dan wholeheartedly. I think that the more that you can do to be educated on the entire process, another thing that we touched on briefly today, but didn't spend a lot of time on that I think is critically important in these processes, both from a recruiting and strategic standpoint, as well as an ethical standpoint, is the completion of lateral partner questionnaires or LPQs. That's something that, also when people ask why use a recruiter, I don't understand how a lawyer can have a full-time job and then manage 5 different LPQs that all seem to be on forms that are just different enough to require information to be calculated and put in different ways. So I'm really looking forward to the next couple of discussions because I think all of our goal here is to arm folks. Lawyers are so sophisticated and educated in the representation of their clients. And I find often that folks are less sophisticated in their own transactions that end up being some of the most important things that they do in their career. So really excited to keep talking about this and make sure that we're getting people great information and resources on that front.
Guess it's just another incident or another example of that old saying, only a fool what's the expression?
Would hire himself as a lawyer.
Yeah, that. Guys and lady, thank you. Thank you very much for an elucidating episode number 1. Look forward to speaking on episode number 2. Audience, come on back. Webinar's over. Episode's over. Bye all.
Yeah, thanks everyone.
Thanks,
Thank
everybody.
you.
Thanks, y'all.
Thanks. Take care, everyone.